If you've ever signed a contract in a language you don't fully read, or handed a legal document to a translator and just hope for the best, this episode is for you. Welcome back. Today I'm joined by the founder of Orion Linguistics, a legal and financial translation specialist with a decade of experience on court documents, government contracts, intergovernmental MOUs, and high-stakes commercial agreements. We're talking about legal translation, what it actually involves, and why getting it wrong can cost you far more than the translation fee. Great to have you here.
Thanks for having me. It's a topic I feel strongly about, so I'm glad we're getting into it.
Let's start with the assumption most people bring to this. Legal translation, it's just translation, but the documents happen to be legal documents. What's the first thing you'd push back on?
That assumption gets people into real trouble. The most important thing I'd say up front is, a single word difference in a legal document isn't just a typo, it's a potential change in legal effect. Take shall and must. In legal drafting, they mean obligations. And when you're translating into traditional Chinese for Taiwan, the established convention is to render that obligation as ing, not bishu, although the two terms are interchangeable in everyday conversation. Get that wrong and the document may no longer accurately reflect the original obligation. So the translator really have to understand the terminology of the target legal system.
Right. And this connects to something I didn't expect to be complicated, which is traditional Chinese isn't unified across different jurisdictions, is it?
Exactly. And this is a mistake I see more often than you'd think. Taiwan, Hong Kong, and Macau all use traditional Chinese, but they have completely different legal systems and their own drafting conventions. The same concept might be expressed with different terminology across those three jurisdictions. So if a translator mixes them up, uses Hong Kong legal phrasing in a document for Taiwan courts, it's not just a style problem. It can affect whether the document is consistent with applicable laws. A fluent document isn't necessarily a correct one.
That's a really unsettling distinction. You could read a document, think it's fine, and not realize it's using the wrong jurisdiction's vocabulary.
Yes, and a general translator might not catch it, which is why finding a legal translator for the job is so important.
Let's talk about the hardest part, preserving the actual legal effect of a document. Not just converting the words, but making those words do the same thing in another language.
This is genuinely the most demanding part of the work. You have to first understand what the legal relationship is in the original, what rights and obligations are being created, transferred, or restricted. Then you have to reproduce the same legal effect in the other language. That's legal writing in two languages simultaneously, not just linguistic transfer.
What happens when the original document is itself ambiguous? Like, the contract wasn't perfectly clear to begin with?
That happens more than people realize. Sometimes the language is vague, but my job is still to be faithful to the original. I can flag it for the client. This clause has ambiguity. You may want to address it. But I can't resolve that ambiguity through translation. That would be changing the legal effect of the document, which is not my role.
So you're not there to fix the contract. You're there to render it accurately, including its imperfections.
Exactly. And actually, I've had clients come to me after they'd already signed a contract. And the translation revealed that their understanding of certain provisions was completely different from what the contract actually said. At that point, translation can't help them. Once a contract is executed, a translation cannot change its legal effect. If you need translation assistance, get it before you sign, not after.
That's a stark example. Okay, I want to stay on terminology for a moment, because there's a point in your article about differences between legal systems that I found genuinely surprising. The word defendant. It doesn't mean the same thing across jurisdictions?
Right. In Taiwan's criminal justice system, a person can be referred to as beigao, which we typically translate as defendant, during investigation by the prosecutors, before any formal charges. In certain common law jurisdictions, including the US, a person generally doesn't become a defendant until formal charges have been filed. So depending on the procedural context, suspect or accused person might actually be a more accurate translation than defendant. The terminology has to reflect where that person actually is in the legal process, not just be a default word swap.
So the same Chinese word could map to different English words depending on regulations of different jurisdictions?
Yes. And getting that wrong has real implications for how the document reads in terms of procedural status and legal rights.
Let's shift to something that I think catches people off guard: translating platform terms in user interfaces. Privacy policies, terms of service. What's the challenge there?
The core challenge is that the translator often can't see the actual interface. You're translating text for a system, but if you can't see what is displayed to users, you can end up with a translation that reads smoothly but is problematic. The source text said certain resources could be used only when authorized and could not be used when unauthorized. A translation rendered that as unauthorized resources may not be used. Use in other situations is allowed. The source text divides the world into three buckets: authorized, unauthorized, and everything else. That third category isn't stated out loud. The translation collapses it into two: unauthorized and everything else. If for any reason the scenario falls into a gray area, the translation could potentially be misleading. When contextual information is limited, staying close to the source text is the safest approach.
And connected to that, these documents also change over time. Platform terms get updated constantly.
Yes, and this is where version control becomes a real issue. If a translation substantially changed the original phrasing, even to improve readability, then every future update to the source document requires an audit of the translation. Did that change carry through? Does the revised version still hold? That creates ongoing maintenance costs. Clients would expect that if the source remains unchanged between versions, the translation shouldn't need revision either. This is a reasonable expectation, but it only holds if the original phrasing was preserved. And sometimes translators disagree with a previous translation. But any changes in wording could mean throwing away established precedent. Therefore, any such changes must be done with extreme care. Phrasing choices made during translation have long-term consequences. For living documents, legal translation isn't a one-time task. It's a long-term commitment that starts with how the first version is handled.
We've been talking mostly about what the words say, but what about the structure? The shape of the document itself?
This is something people underestimate. Legal documents are often the result of months of drafting and negotiation. Every clause, sometimes every sentence, can reflect a compromise that took weeks to reach. So the goal isn't to rewrite the document more elegantly, it's to faithfully reproduce its structure and content. In practice, translators rarely see all the draft versions exchanged during negotiations. Clients can't always share them for confidentiality reasons. Preserving the source structure helps maintain the arrangement and emphasis the parties ultimately agreed on, even when you can't see how they got there.
Which brings up confidentiality, because these documents are often extremely sensitive.
Yes, legal translation frequently involves trade secrets, litigation strategies, confidential transactions. Confidentiality here isn't just about the translator's personal ethics. It's about the entire process. Are machine translation tools being used? Is data being uploaded to third-party platforms? Where is the document stored? Are there conflicts of interest? These are all real questions. Selecting a provider with robust confidentiality safeguards isn't optional. It's part of risk management.
And then on top of all of that, there are deadlines.
Always. Court filing deadlines, transaction closing dates, contract execution schedules. These are not flexible. A translation that arrives one day late can derail a deal or cost someone their right to file. So project management is genuinely part of the job. It's not enough to be accurate. You also have to be reliable and understand what's at stake if you're not.
So when you're choosing a legal translator, it's credentials plus track record on delivery.
Both matter equally. And that's really the foundation of how I built Orion Linguistics, on the conviction that translation is a professional responsibility, not a commodity. That means structured workflows and subject matter expertise, not just language skills.
That's the perfect place to land. For anyone listening with a legal document that needs translating, get a professional involved early, get clarity before you sign, and don't underestimate what's writing on the words. Thank you so much. This has been genuinely eye-opening.
Thank you. And to your listeners, the time to handle translation is before the document matters, not after.